Zwelithini Gabela, Phindile Cynthia Ncube, Dineo Mukweli. Thank you, Your Worship. Your Worship, we have already set out the schedule that this is a Schedule 5 bail application, and the defense has no objection to that.
Mr. Mudau will confirm.
Yes, the court, Your Worship, I confirm.
That about the schedule.
Yes, Your Worship, although we knew this morning, but there's no problem.
I beg your pardon.
I'm saying, although we knew this morning, but we agreed, we confirm.
It's one of two things. If you want to do a research, tell me, I'll give you time to do research and come on.
We have already done the affidavit. I anticipated it, so I drafted the template and then we completed it.
Yeah, copy and paste. Thank you. Ms. Ndebele.
Confirmed, Your Worship.
The schedule.
Confirmed based on what we did. Confirmed, Your Worship.
Thank you. Mr. Murufe.
Confirmed, Your Worship.
Thank you. That being the case, then Mr. Mudau, you may proceed.
Yes, Your Worship. I've already prepared, Your Worship, the affidavit in support of the bill. I'll start with accused number 1. Yes. And again, Your Worship, we have also agreed with our colleagues that the bail is not opposed. And I'm reading the affidavit in support of bail. Thank you, Your Worship. I, the undersigned Samuel Dumisani Khumalo, do hereby state under oath as follows. I am the accused as well as the applicant in this matter. The facts deposed herein are to the best of my knowledge both true and correct unless otherwise stated. I've been advised that the charge against me falls within the ambit of Schedule 5 of the Criminal Procedure Act 51 of 1977 and that the onus rests upon me to produce evidence which satisfies the court that the interest of justice permits my release on bail. I further confirm that I have been advised that the information herein contained may be used against me during the trial. I place the following personal circumstances on record, Your Worship. I am 56 years of age. I was born on the 18th of March 1969 within the Republic of South Africa, and I am a South African citizen. My highest level of education is a bachelor's degree. I am single. I have 3 children, Njabulo, Panele, and Ngumbi. I reside at 68 Flower Crescent, Edgefield Crescent, The Reef. I've been a resident.
I beg your pardon, repeat the address.
68A.
68A.
Moonflower Crescent. Yes, in Edgefield. I've been resident at this address since 2012. I consider this address to be my permanent place of residence because I have strong family ties within the area. During my arrest, I was employed at South African Police Service Crime Intelligence, address 463 Presca Road, Erasmus Club, Pretoria. I've been advised to disclose to this court in terms of section 60(11)(1)(b) whether I have previous convictions and pending cases against me, and that should I disclose false information, I could be prosecuted and upon a verdict of guilty and be sentenced to imprisonment. I have no previous conviction against me. I have no pending case against me. I have no outstanding warrant of arrest. I have no protection order or harassment order against me. I was arrested on the 26th of June, 2025, with regard to this charge of fraud and corruption, and I have been in custody since then. I can afford an amount of 1,000 for the purpose of bail. I cannot afford to forfeit this amount of money to the state by not being present in court when I am required to be. I undertake to do the following. I undertake not to do the following, I need to say, Your Worship, to endanger the safety of any individual, the public, or commit any offense while on bail, attempt to evade my trial, since I intended to stand my trial and clear my name, to intimidate or attempt to influence any witnesses the state intends to use, attempt to destroy or conceal any evidentiary material that the state intends to use, undermine the proper functioning of the criminal justice system on the bail system, disturb public peace and order. In respect of the merit of the charges against me, I place the following on record, Your Worship. I intend to plead not guilty to the charges leveled against me. I deny all the allegations against me. I will exercise my right to remain silent at this stage. My defense will be disclosed at my subsequent trial. I undertake to abide by any bail conditions this honorable court deems fit should bail be granted in my favor. In the light of the above, I therefore humbly submit to this honorable court that bail be granted in my favor. I confirm the above information to be both true and correct, and then that's done and signed before me at Tshwane on the 27th day of June 2025. And Your Worship, before we could give them, I also discussed the affidavit with my colleagues, and then they said no, they were fine with it. And then there's a signature there of the accused as a deponent. So may I give it to the accused so that Your Worship can confirm?
Just bring it straight to me. If your colleagues tough and pass. Mr. Khumalo, understand? You confirm what's been read out in support of your bail application by your attorney?
Yes, Your Worship.
Thank you. This document is accepted, marked Exhibit A. You may see.
Thank you, Your Worship. For accused number 2, I, the undersigned Nicholas Pilani Lushava, do hereby state under oath as follows. I am the accused.
Just a minute. Let's go back to this affidavit.
Your Worship.
Pass it to Mr. Mudabu. Look at the last page, Mr. Mudabu. The commission.
The commission, yes, Your
The
Worship.
last, the very, very last.
Yes.
Commissioning of Oaths Act dictates that the commissioner must write full address. What is standing there?
Yeah, he only wrote the street address. Then we will rectify that, Your Worship, quickly.
When? Next week?
Now, because he's here, we asked the word of the court orderlies to help us.
I frown. These things of doing things like we're selling little chips at the corners, stop sign, I don't approve of it.
My apology, Your Worship.
Okay.
Yes, we will rectify it now.
Proceed to rectify it, please. I
Okay.
cannot accept a half-baked potato. Where's the Commissioner of Oaths? Full address, please, in front of the deponent. And let him also do the necessary amendment and signing.
My apology, Your Worship.
You know, there's a recent case that has come out now from the Western Cape, from one of the high courts. If the document is not properly commissioned, it's not an affidavit. Proceed.
Thanks, Your Worship.
I'm just checking it now. Continue.
Yes, Your Worship, it will help me. I, the undersigned Nicholas Pilani Lushava, do hereby state under oath as follows. I am the accused as well as the applicant in this matter. The facts deposed herein are to the best of my knowledge both true and correct unless otherwise stated. I have been advised that the charge against me falls within the ambit of Schedule 5 of the Criminal Procedure Act 51 of 1977, and that the onus rests upon me to adduce evidence which satisfies the court that the interest of justice permits my release on bail. I further confirm that I have been advised that the information herein contained may be used against me during my trial. I place the following personal circumstances on record. I am 41 years of age. I was born on the 1st of August 1983 within the Republic of South Africa. I am a South African citizen. My highest level of education is Masters in Management. I am married. I have 4 children. I reside at 1564B, Waring Street, Waverley in Pretoria. I've been a resident at this address since 2021. I consider this address to be my permanent place of residence because I have strong family ties within the area. During my arrest, I was employed at South African Police Service as a police officer. at 463 Priska Street, Erasmus Club. I have no previous conviction against me. I have one case pending against me. I have no outstanding warrant of arrest. I have no protection or harassment order against me. And then I have the following previous conviction against me. It's none, Your Worship. And then I have the following case pending against me. It's the case of corruption and defeating the end of justice. The case is reminded, Commissioner, before this court for disclosure on the 13th of August 2025. And then I was arrested on the 26th of June 2025 with regard to this charge of fraud and corruption, and I have been in custody since then. I can afford an amount of 1,000 for the purpose of bail. I cannot afford to forfeit this amount of money to the state by not being present in court when I'm required to be. I undertake not to do the following: endanger the safety of any individual, the public, commit any offense while on bail, attempt to evade my trial since I intended to spend my trial and clear my name, intimidate or attempt to influence any witness the state intends to use, attempt to destroy or conceal any evidence, material the state intends to use, undermine the proper functioning of the criminal justice system on the bail system, disturb public peace. I intend to plead not guilty to the charge leveled against me. I deny all allegations against me, and I will exercise my right to remain silent at this stage. My defense will be disclosed at my subsequent trial. I undertake to abide by any bail condition this honorable court deems fit should be granted in my favor. In light of the above, I therefore humbly submit to this honorable court that bail be granted in my favor. I confirm the above information to be true and correct. Thus done and signed before me at Tshwane on the 27th of June 2025. And then it's initialed, Your Worship, and then the signature of the accused is there. And on this one, we make sure on the last page the address is proper, Your Worship.
Just before you proceed, the case I refer to is not Gauteng High Court, case number 3988 of 2012. It was given by Justice Katri Silwane. It's a matter between Absa Bank versus Gerardas Bartholomeus Botha Nominal Officio and two others.
Absa Bank versus?
Absa Bank versus Gerardas Bartholomeus Botha Nominal Officio. First respondent. Second respondent was Belinde Botha Nominal Officio. Third respondent was Gerardas Bartholomeus Botha in person. Third respondent. It just deals with the house. The sloppiness of commissioning of courts can cause the document not to be considered an affidavit. Proceed.
Thank you very much, Your Worship. For accused, Your Worship, for accused number
3.
Number 3. I, the undersigned, Nozipho Precious Madondo, do hereby state under oath as follows. I am the accused as well as the applicant in this matter. The facts deposed herein are to the best of knowledge both true and correct unless otherwise stated. I've been advised that the charge against me falls within the ambit of Schedule 5 of the Criminal Procedure Act 51 of 1977, and that the onus rests upon me to adduce evidence which satisfies the court that the interest of justice permit my release on bail. I further confirm that I have been advised that the information herein contained may be used against me during my trial. I am 49 years of age. I was born on the 31st of January within the Republic of South Africa. My highest level of education, a master's degree. I am married. I have 4 children, Gugu, Mbali, Apiwe. You can see that I reside at 114 Louisa Park, Roy Hayes Kral, Centurion in China. I've been staying in that address since 2023. During my arrest, I was employed at SABC Crime Intelligence, 463 Presca Road, Erasmus Kloof, Pretoria. I've been advised to disclose to this court in terms of Section 60(11)(b) A, whether I have any previous convictions and pending cases against me, and that I should disclose false information, I could be prosecuted and upon a verdict of guilty be sentenced to imprisonment. I have 1 previous conviction against me expunged. I have the following previous conviction: assault, where 500 fine was imposed but suspended, and it was in 2010. I was arrested on the 26th of June 2025 with regard to this charge of fraud and corruption, and I've been in custody since then. I can afford an amount of 1,000 rand for the purpose of bail. I cannot afford to forfeit this amount of money to the state by not being present in court when I am required to be. I undertake not to do the following: endanger the safety of any individual, the public, or commit any offense while on bail, attempt to evade my trial since I intend to stand my trial and clear my name, intimidate or attempt to influence any witness the state intend to use, attempt to destroy or conceal any evidence material the state intend to use, to undermine the proper functioning of the criminal justice system or bail system, to disturb the public and order. In respect of the merits to the charges against me, I place the following on record. I intend to plead not guilty to the charges leveled against me. I deny all allegations against me, and I will exercise my right to remain silent at this stage. My defense will be disclosed at my subsequent trial. I undertake to abide by any bail condition this honorable court deems fit, should bail be granted in my favor. In light of the above, I therefore humbly submit to this honorable court that the bail be granted in my favor. I confirm the above information to be true and correct. That's done and signed before me at Tshwane on the 27th of June 2025 by the deponent. And the deponent commissioner signed and initialed every page. And on our last page, the commissioner of oath wrote everything in full.
Let's go back to accused number 2, just for a moment. You confirm the Exhibit B to be your statement?
Yes, sir.
And the contents thereof?
Yes, sir.
Thank you. You may be seated. And Mrs. Nozipo, you may stand. The affidavit read out, you confirm that it is yours?
That's correct, Your Worship.
Very well. And thank you. You may be seated. It's marked Exhibit C. Proceed, sir.
Thank you, Your Worship. For accused number 4, I, the undersigned Maperemisa, Josias Likalakala, do hereby state under oath as follows. I am the accused, as well as the applicant in this matter. The facts deposed to herein are to the best of knowledge, both true and correct, unless otherwise stated. I have been advised that the charge against me falls within the ambit Schedule 5 of the Criminal Procedure Act 51 of 1977, and that the onus rests upon me to adduce evidence which satisfies the court that the interest of justice permits release on bail. I further confirm that I have been advised that the information herein contained may be used against me during trial. I place the following personal circumstances on record. I am 56 years old. I'm 56 years of age, and I was born on the 3rd of February 1969 within the Republic of South Africa. I am a South African citizen. My highest level of education is a Masters of Public Administration. I am married. I have 3 children, Ulebukeng, Tato, and Unkhatlile. I reside at 949 Stangeria Road, Montana Park, in Pretoria. I have been resident at this address since 2019. Your Worship, I see. During my arrest, I was employed at the South African Police Service, but I see the Your Worship, he did not write the address in full. Also, let's quickly approach him to just amend there to put the full address.
I cannot do that without the Commissioner of Police.
Thank you, Your Worship.
You know what they say in Sotho? It's a Where's our interpreter?
To what is to see.
Just try to interpret that. What's a market for? Yeah, you see things.
Thank you, Your Worship. During my arrest, I was employed at SAPS Crime Intelligence, 463 Presca Street, Erasmus Club, Pretoria. I have one previous conviction against me. I have no pending case against me. I have no outstanding warrant against me. I have protection. I have no protection order or harassment order against me. I have the following previous conviction, Your Worship: reckless and negligent driving. It was in 2001, where admission of guilty was paid of 1,500, and it doesn't have any pending case. I was arrested on the 26th of June 2025 with regard to this charge of fraud and corruption, and I have been in custody since then. I can afford an amount of 1,000 rand for the purpose of bail. I cannot afford to forfeit this amount of money to the state by not being present in court when I am required to be. Endanger the safety of any individual. I undertake not to do the following: to endanger the safety of any individual, the public, commit any offense while on bail, attempt to evade my trial since I intend to stand my trial and clear my name, intimidate or attempt to influence any witness the state intend to use, attempt to destroy or conceal any evidence material the state intend to use, to undermine the proper functioning of the criminal justice system or the bail system, to disturb the public peace and order. In respect of merits, Your Worship, for the charges against me, I place the following on record. I intend to plead not guilty to the charge leveled against me. I deny all allegations against me and will exercise my right to remain silent at this stage. My defense will be disclosed at my subsequent trial. I undertake to abide by any bail condition this honorable court deems it should bail be granted in my favor. In light of the above, I therefore humbly submit to this honorable court that bail be granted in favor of me. I confirm the above information to be true and correct, and Your Worship, it's signed there, that's done and signed at Tshwane on the 27th of June 2025, signed by the deponent, commissioned in full, Your Worship.
May I stand, Mr. Josias? You confirm that this is your affidavit?
Yes, I confirm, Your Honor.
And thank you. You may receive it. Mark Exhibit 3. Thank you. Proceed.
Thank you, Your Worship. Those were my submissions in terms of the affidavit for accused 1 to 4, and may bail be granted in their favor, Your Worship.
that's too premature. Thank you. This is your application for now 1 to 4.
I thought maybe I have covered everything there, Your Worship.
You say may bail be granted, and we haven't even had arguments. We haven't had this prosecution. That's why I'm saying.
Oh, yes. Yes, I'll come back.
Thank you.
Yes.
Thank you. For number 5. Yeah, it's a
Thank you, Your Worship.
Sorry. Would you be so kind to shift so Mrs. Ndebele have a space, please? Thank you, ma'am.
Thank you, Your Worship. I am instructed, accused number 5 has deposed to a bail affidavit, and I'm instructed to present same in his application for bail. Your Worship, if the same is in order, may I be permitted to read?
Please go ahead, ma'am.
Your Worship, before I do so, I am going to disclose accused number 5's home address, his residential address. I request that that be not published as part of the publication for just his safety, and I think just for his privacy. Otherwise, the rest will know.
That's not going to happen, ma'am, Ms. Ndebele. You see this document, the charge sheet, his address is already in this document. And that once it's accepted will form part of this document, court document. And this is a public document. And the public has got free access to the document.
As it is the copy.
So,
As it is the copy.
thank you.
This is an affidavit in support of bail application. I, the undersigned citizen, Zwelithini Gabela, hereby declare under oath as follows. I am the applicant in this application, in which I seek relief from this honorable court to be released on bail. I respectfully submit, as I will demonstrate herein, that the interests of justice permit my release on bail. I make this affidavit on my own free will and have not in any way been unduly influenced to depose thereto. The facts herein contained, save where expressly indicated to the contrary, are within my personal knowledge and belief and are both true and correct. The purpose of this affidavit is to provide the Honorable Court with my personal circumstances, as well as to address the factors to be considered by the above Honorable Court as contained in Section 60, subsection 4 to 60, subsection 9 of the Criminal Procedure Act 51 of 1977. As enunciated above, I am the applicant in the above-mentioned matter, an adult male, aged 56 years old, with the following personal particulars and background. Date of birth, 29 August 1969, citizenship, South African. I do not hold any dual citizenship with another country. Travel documents, I have an official passport as well as a South African passport. Relatives resident outside the Republic of South Africa. I do not have any relatives outside of the Republic of South Africa. Assets outside the Republic. I do not have any assets outside the Republic of South Africa. Personal background. Place of birth, KwaZulu-Natal. Tertiary or other training, BTEC policing. Work history. I am currently employed as a general in the South African Police Service, with my work situated at South African Police Service Technology Management Services, 101 Douglas Street, Coburn, Pretoria. General remarks regarding background and permanency. My personal place of residence is situated at 582 Ferdy Street, Pretoria, where I'm residing with my wife since 2012. I therefore have a strong emotional, family, and social ties in the Gauteng area. I confirm that I'll be residing at the aforementioned address for the full duration of this trial. I will stand my trial should it proceed against me. I am eager to stand trial also so that I can put on record the true facts of the incident which is the basis of this case and prove my innocence. I trust that the South African legal system will afford me a fair chance to answer to the allegations against me, and as such I am eager to cooperate with the process and prove my innocence. Marital status and general particulars of spouse. I am married to Colonel Kumzile Grace Gabela. Dependents. I have 5 dependents, being my wife, daughter, and 2 of my late brother's children whose full upkeep I am responsible for. Occupation. I am gainfully employed on a full-time basis as a general in the South African Police Service. Assets. I am the owner of immovable property situated at 582 Ferry Street, Pretoria. I am also the owner of a motor vehicle. Availability and sources of funds for bail. I'm able to pay bail in the amount of 1,000 rand. History of antisocial behavior. Previous convictions, none. Pending criminal cases, none. I have been duly warned and informed by my legal representatives that it is an offense not to declare the correct facts as to my previous convictions and pending cases, that I can be convicted and punished in law should I not declare any relevant information in regard thereto and I understand it. Arrest and factual background thereto. Date of arrest. I was arrested on the 26th of June 2025 and I've been in custody ever since then. Offenses.
It's only yesterday. It sounds No, never mind.
On a cold winter day.
It's only yesterday and it's made to sound like last year in 2024. Proceed, ma'am.
It's a cold 24 hours. Offenses charged with fraud and or corruption. However, I have not been furnished with the full particulars of the alleged offense. Intended plea. I intend to plead not guilty as I did not commit any fraud and or corruption. I have been advised that it is unnecessary to fully set out the basis of my defense at this stage of the proceedings. Defense. I deny that I had any intention to commit the crimes as appear in the charge sheet. My legal representatives will address the court fully on the legal issues relevant at the hearing of this issue. Submissions regarding factors to be considered when deciding whether bail should be granted. Schedule of the Criminal Procedure Act, matter results under Schedule 5. Considerations in terms of Section 60, subsection 4A to E. Danger to the public or individual safety. I respectfully submit that my release on bail will not endanger any person's safety. I harbor no resentment against any particular individual or the general public. Likelihood of evasion of trial. I voluntarily handed myself at the Brooklyn police station when I heard that the police were looking for me at my place of work on the 26th of June 2025. I also have a stable emotional, family, work and social situation within this honorable court's jurisdiction. I have no intention of absconding and living the life of a fugitive. I also cannot afford to forfeit any amount of bail that may be set by this honorable court. Interference with witnesses or evidence. I have not been provided with a list of possible state witnesses. I do, however, undertake not to interfere with any state witnesses should their identities become known to me. I have no access to evidentiary material held by the investigating officer. I will not interfere with the investigation of this case. Jeopardy to functioning of the criminal justice system or bail system. I submit that I will not jeopardize the functioning of the criminal justice and or bail system. Exceptional circumstances, presence or absence thereof, which may lead to undermining public order or peace. I was advised, which advice I accept, that this subsection is not applicable to my application. Other relevant factors to be considered by the court. I respectfully submit that my further incarceration will have a detrimental effect on my family. I am innocent of the charges leveled against me. I have been a law-abiding citizen with no previous conviction, a respectable member of the South African Police Services since 1991, with an impeccable record and an astute member of my society. I have already been incarcerated since the 26th of June 2025, emphasis, Your Worship, and there is absolutely no justification to detain me any longer, nor is it in the interest of justice to do so. I will stand my trial and adhere to any reasonable conditions set by this Honorable Court. In the premises, taking into consideration the relevant schedule, the charges resort under, I respectfully submit that the court should grant bail to me in an appropriate amount with such conditions attached as the court may deem fit. Your Worship, the affidavit has duly been signed today in this court, Your Worship. I beg leave to end up the affidavit.
Mr. Kabela, you may stand. We confirm that this affidavit that's been read out, it is indeed your affidavit.
Yes, I can confirm.
Well, it's accepted, marked Exhibit F. You may be seated. Thank you, Mr. Mobefe. Proceed.
As it pleases this court, this is an affidavit in support of the bail application, read into record. Case number A116/463 of 2025. I, the undersigned, Pindile Cynthia Mingwe, do hereby state under oath as follows. I am the accused as well as the applicant in this matter. The facts deposed to you herein are to best of my knowledge and both true and correct, unless stated otherwise. I've been advised that the charge against me falls within the ambit of Schedule 5 of the Criminal Procedure Act 51 of 1977, and the onus rests upon me to accuse evidence which satisfies the court that the interest of justice permits my release on bail. I further confirm that I've been advised that the information contained herein may be used against me during my trial. I place the following personal circumstances on record. I'm 51 years old, and I was born on the 1974 June, the 27th day of June, within the Republic of South Africa, and I'm a South African citizen. My highest level of education is honors degree. I am married. I have 2 children, Katero and Zaziena, and I reside at Unit 6, Hornbeck Crescent, 31 Ikawa Street, the Orchards Extension 36. I've been resident at this address since 2014. During my arrest, I was employed at SABC Crime Intelligence here in Pretoria. I've been advised to disclose to this court in terms of Section 60(11)(b), in brackets A, whether I have any previous convictions, pending cases against me, and that I should disclose false information. Should I disclose false information, I could be prosecuted and upon verdict of guilty be sentenced to imprisonment. I have no previous convictions against me, no pending cases or outstanding warrant and protection and harassment orders against me. I was arrested on the 26th day of June 2025 with regards to this charge of fraud and corruption, and I've been in custody since. I can afford an amount of 1,000 rand for the purpose of bail, cannot afford to pay this amount money to the state by not being present in court when I'm required to be. I undertake not to do the following: endanger the safety of any individual, public, or commit any offense whilst on bail, attempt to evade my trial since I intend to stand my trial and clear my name, intimidate or attempt to influence any witness the state intends to use or call, attempt to destroy or conceal any evidential material to the state intends to use, undermine proper functioning of the criminal justice system or the bail system, disturb public peace and or order. Thus, signed on the 27th day of June by the accused in the presence of his legal representative and duly commissioned. With leave of the court, can I hand the affidavit as an exhibit?
Thank you. You may stand, Cynthia. You confirm this is your affidavit?
Yes, I confirm.
Very well. You may be seated. It's accepted. Marked Exhibit G. Thank you. Proceed.
As it pleases this court, affidavit in support of bail application on behalf of accused number 7, case number 16, stop 463 of 2025. I, the undersigned, Neo Mukwele, do hereby make an oath and say, I'm the accused and as well as the applicant in this matter. First supposed to herein are, to my best of my knowledge, and are both true and correct. I've been advised that the charge against me falls within the ambit of Schedule 5 of the Criminal Procedure Act 51 of 1977, and that the onus rests upon me to adduce evidence which satisfies the court that interest of justice permits my release on bail. I further confirm that I've been advised that the information herein contained may be used against me during trial. I place the following personal circumstances on my record. I'm 30 years old, born on the 2nd of May 1995 within the Republic of South Africa, and I'm a South African citizen. My highest level of education is a Masters of Business Administration, MBA. I'm married. I have one child, Mamothame Mukwele, 2 years old, female. I reside at 17 Roy Stake Road at Dry Boss Complex, Pretoria, Annalene. I've been resident at this address since 2020. I consider this address to be my permanent place of residence because I have strong family ties within the area. During my arrest, I was employed by the South African Police Service, Crime Intelligence Technical Support since November 2024 here in Pretoria. I've been advised to disclose to this court in terms of Section 60, 11B, bracket A, whether I have any previous convictions, pending cases against me, that I should disclose false information. Should I disclose false information, I could be prosecuted and upon verdict of my guilty, be sentenced to an imprisonment. I have no previous convictions, no pending cases, no outstanding warrants, and or protection or harassment orders against me. I was arrested on the 26th day of June 2025 with regards to the charge of fraud, corruption and misrepresentation, and I've been in custody since then. I can afford an amount of 1,000 rands for the purposes of bail. Cannot afford to forfeit this amount of money to the state by not being present in court when I'm required to be. I undertake not to do the following: endanger the safety of any individual, the public, or commit any offense whilst on bail, attempt to evade my trial since I intend to spend my trial in clear money, intimidate or attempt to influence any witness the state intends to use or call, attempt to destroy or conceal any evidentiary material the state intends to use, undermine the proper functioning of the criminal procedure system or the bail system, disturb public peace and order. In respect of the merits of the charges against me, I place the following on record. I intend not to plead not guilty to the charges leveled against me. I deny all allegations against me and will exercise my right to remain silent at this stage. My defense will be disclosed at my subsequent trial. I undertake to abide by any bail conditions this Honorable Court deems which should bail be granted in my favor. In the light of the above, I therefore humbly submit to this Honorable Court that the bail be granted in my favor. I confirm the above information to be both true and correct. Thus done and signed on the 27th day of June by the deponent and commissioned by the Commissioner of Oath. With the leak of the court, I wish to hand over the affidavit as an exhibit.
Thank you. Do you mind to shift? Stand, please. Do you confirm that this is your affidavit, Mrs. Mukwele? Thank you. You may be seated.
As it pleases this court, that is the case for my client's application.
Affidavit is accepted, is marked as Exhibit H. Ms. Chachwai.
Thank you, Your Worship. Your Worship, the state did not prepare a bail statement in light that this bail application is unopposed. Therefore, the state will address the court from above.
Yes. You know that you have to put reasons why you are not opposing bail.
That is correct, Your Worship. I am going to do so. Your Worship,
just a minute. Mr. Mudau, Ms. Ndebele, and Mr. Mulife, is it correct for me to assume that there will not be additional evidence other than the Exhibit A to H that you will be adducing in support of the client's bail applications?
That is true, Your Worship.
And that would then close the application for case number 1, 2, 3, 4, 5. Mr. Mudau.
Yes, Your Worship.
Ms. Ndebele.
Thank you, Your Worship. The affidavit constitutes accused number 5's bail application, Your Worship. If the court is so satisfied, that is the
applicant's case.
Applicant number 5's case.
Mr. Mulife.
I confirm that the affidavits represent the case of application for bail application on both accused, Your Worship.
6 and 7.
6 and 7.
Very well. Thank you, Ms. The respondent may proceed.
Thank you, Your Worship. Your Worship, the reasons for the state not to oppose bail in this matter is that all accused addresses have been confirmed. Their employment confirmed.
Just a minute, Mrs. Chachuari. That being the case, I am interested to hear you. Accused number, you said, accused number 1, that is Mr. Samuel Khumalo's address. Here it reads 69 Moonflower Crescent, Centurion Swan. Here it is 68A Moonflower Crescent, Catchfield. And you say it has been confirmed. And 68 and 69 can never be the same thing. The last time I did maths, it was not the same thing.
The confirmed address, Worship, is 69 Moonflower Crescent. That is
what is where does 68 come from? Because 68 is in the affidavit, which is more cogent than the 16.
that is a mistake, an honest mistake, Your Worship. It can be rectified
By who?
by the author of the J15. Because what we have on the church worship is that the address is 69. And on the affidavit,
It says 68. 68A.
Mr. Budal,
No, don't talk to them. You're talking to me. I'm taking you up on what you say you have confirmed. And the affidavit says 68. And you say it's been confirmed, and it says 69 on your chart sheet. So how do we bypass this contradiction? Please help me.
Your Worship, I will request the defense to give us the correct address, because the address that we have is 69 Moonflower. So if the one is having the 68 on the affidavit, it needs to be confirmed by the defense.
You know what section 60 subsection 4 provides? Then I must postpone the case to cause Tswane or the applicant to bring it in from Tswane or from the title deeds to confirm this discrepancy. But proceed, ma'am. We will get to that when I speak to Mr. Mudau. Proceed.
Thank you, Your Worship.
Bail not opposed address is confirmed.
That is correct, Your Worship. And their employment confirmed as members of SABC in crime intelligence, and they are in senior management. Investigations are finalized in this matter, Your Worship.
Investigations finalized, yes.
That is
Number
correct,
4.
Your Worship. There is no number 4.
Oh, I thought you were further. Sorry. Are those the only reasons?
Yes, that is correct, Your Worship.
Okay. Anything else from your side? You want to consult? Go on.
Yes, Worship. There is number 4, Your Worship, pardon me. Number 4 is that we don't view them as flight risk. That is another reason for the state not proposing bail.
Yes.
I am done with the reasons for not opposing bail, Your Worship. Now I want to address the court.
Your address comes after their address. Help me here. Your witnesses, are they individual ordinary citizens? Who are they? I don't need their names, I just need to know.
The witnesses in this matter, Your Worship, most of them, they are also in the employ of SABC, based in crime intelligence, so they are not just members of the public.
You say most of them. What about the list of them?
There are very few that are members of the public, Your Worship.
Yes, that's why I'm saying what about the list of them? Am I not endangering them?
Your Worship, we don't intend to publish their names at this stage, Your Worship.
I don't say publish their names. I don't say that. I have a responsibility, a very huge responsibility. You understand?
Yes, I do, Your Worship.
Yes. They apply, you oppose or you don't oppose, but ultimately it's me who is on the firing line from the media, from the party, from everyone else, from the outcome. So I must be diligent. I don't want to be defended number something when there is a thing against the unlawful detention or the state witnesses disappeared and the magistrate was negligent.
Understood, Your Worship.
Yes. That's why I'm asking. I assume they have been disarmed of their firearms.
That is correct.
Private and public.
That is correct, Your Worship.
Let's just put it on record. What about the list of witnesses that are members of the public, not members of SABC? What's the profile of their safety? Just for the record, I have negotiated with my assistant here that we can proceed. It is past lunch. It is 1:14, and she agreed that we may proceed. So I'm not breaking any labor laws.
Thank you.
Proceed, ma'am.
Your Worship, at this stage, the state is not going to list the witnesses because there are other investigations that are still ongoing.
I thought the investigation was done.
Not this matter, but on other matters where some of the accused are involved.
You're speaking like a biblical tongues, you know. I fail to understand some cases, some of they are.
There are other cases that are ongoing, the investigations are still ongoing.
Yes.
And some of the accused before court, they are implicated on those matters.
Yes.
That is why I'm saying we are not going to list the names of the witnesses.
Yes.
Yes, that is why I'm saying this.
What sway do they hold to the individual public witnesses, not SABC members? Given that you say it has been emphasized several times that they are holding they are high-ranking officials in SABC. So what sway do they hold to influence those witnesses, be it in SABC, be it outside of SABC? SABC is South African Police Services, just to explain the acronym.
You mean the witness or the accused?
The accused. Let me put it in a proper context so that you understand. The state says you do not oppose bail, that the 7 accused be released on bail. Beautiful. But I have to know the sway that they hold in relation to their high-ranking, I don't know what, senior management over the juniors or those that will be witnesses, so that I know that those that will be witnesses without knowing their names are safe, and those that are in the public sphere are not in the South African Police Service are equally safe when they are released. That is the context of my question.
Okay, Oshi. For accused number 1, 2, 3, 4, 6, and 7, they are in the executive management of the entire crime intelligence in South Africa. Yes. So for the members of the crime intelligence or their colleagues, it would be dangerous for us to enlist their names now as witnesses because they have to be protected.
So if they have to be protected, then they are in danger. Maybe you may stand, Silva here.
So, we do not view the witnesses to be in danger.
But just for the record, I've been speaking to Ms. Hlachwayo. Yes. Now you are Ms. Sirunye. Yes.
Your Worship, what we try to portray to the court is that the accused being in senior positions and in management and having witnesses in the same department, and there are other investigations that are ongoing in relation to other matters. Some of the accused being subject of those. We do not want to compromise these other pending investigations by listing the names of the witnesses involved in this case. However, we are confident that the witnesses are not in danger as...
what informs that confidence?
Is the investigations that we've done and the mechanisms that we put in place to ensure their safety. But then if we were to list them, put their names up, then compromising.
No.
That is why we are not listing their names.
There's a lot that, what is not being said is more important than what is being said. Have you ever heard of that phrase?
I have heard of that.
Yes.
Your Worship, and what our issue is, if we were asking the court that the accused should not have contact with certain witnesses or with witnesses, then we would have been compelled to issue the list and say to the court, we ask the court to make an order that the accused should not communicate and or contact witness 1, 2, 3, 4, 5. That does not arise in this case. That is why we say, because of these other pending investigations, we are of the view that to release them would lead to this eventuality that we put in a position where we do not want to. The issue of the list of witnesses does not necessarily arise in this application. We have put up our own measures to ensure their safety, and we can guarantee the court that based on what the mechanisms that we put, and I'm not speaking on behalf of the accused, they are not in a position to can harm or cause any danger to our witnesses. But if we were to release them, then we'll be compromising investigations.
Thank you, Mr. Thank you. Ms. Tlhatshwayo.
Just to wrap it up.
No. Ms. Tlhatshwayo, one last question. What's the status of their employment? I heard it from the affidavits being read out. It says, I was. I don't know whether they are no longer in the employ of police or not. Do you know?
Yes,
are they suspended? Are they still active?
At this stage, Your Worship, we are not sure whether they are suspended, but choose number 2, there is it looks like there is a suspension letter, but we're not sure whether it has been served on accused number 2.
Thank you, ma'am. Back to you, Mr. Mudau. You've been eager to address the court.
So first, Your Worship, I will confirm the address. The address is as it is on the affidavit. And,
No, I'm not talking about the address. I'm closing argument.
Yes, I know. I noted when I was sitting down when you said to my colleague, I will clarify that when I stand up. So I was just noting. We welcome Your Worship that the decision by the state not to oppose our claim.
I can imagine that.
Yes, Your Worship. So we don't have any further submissions other than to welcome their decision not to oppose it. May they be granted.
Mr. Mudau, I've been looking at the criminal procedure here, and it informs me that when a person is, corruption is a Schedule 5 offense, and you have agreed. Are we together?
Yes.
Now you have read an affidavit of Exhibit B. It says accused number 2, Mr. Lushaba, has got a pending case of corruption. In which schedule is that? Because if Schedule 5 and Schedule 5 is Schedule 6.
That's for Your Worship.
Yes.
That's true.
It should have been 5 plus 5 is 10, but the wisdom of the legislature made it 6.
Yes, 5 plus 5 is 6.
So what manje senza? What do we do now?
For him in particular, I will liaise with my colleagues here and see what we can do for him.
I see. You will talk to the prosecution. We'll continue with in relation to accused number 1, 3, 4. You said you have no more submissions.
No, Your Worship, our affidavit it says everything.
It says, no, it does not say anything.
Unless Your Worship there's something the court wants me to...
A lot.
Yes.
Yes. Let us go back to accused number 1.
Yes.
What informs this 1,000 rand bail that you have put forward, which he cannot afford to forfeit? How much does he earn? Because bail is not about what you have in your pocket. Let me ask you this question: what car is he driving? Personal car. Find out.
Let me get everything, Your Worship, from him. What is another thing? Car and I want to ask him.
He's a senior manager in the SABC. He's probably driving a BMW X5 with 80 liters of petrol or diesel. And to fill it up, it's 2,000 rand, and he fills it up every 2 weeks. But he's offering 1,000 rand as bail. What is he? I'm getting to what is his earnings. Bail is about the means. It's not about what you have in your what is in your purse.
Yes.
Yes. Be careful. All I want to know, what is his net salary? I can Google it and it will not be nice. And how long has he been in SABS? South African Police Service. How many years?
1991. Yeah, the carrier worship.
No. I was just illustrating that.
Okay. The net is 74,000.
I beg you, the net is 74,000.
Yes.
And the person, and naturally can, okay, 74, and he can pay 1,000 rand bail. How much, what is the value of the house that he has? At least according to Tshwane,
Municipality.
Tshwane valuation.
Oh, okay. And then
Someone's beginning to sweat now. Or put differently, what is the rates and taxes? How much is the rates he pays to the municipality? Not electricity, just the rates.
Your worship, the rate and taxes is 3,000, and
So the value of the house is just over 3 million. Yes, I can tell you that.
Okay. Okay.
Yes?
Yes, and the levy is 1.2.
Plus levy.
Yeah, plus levy.
You mean 1.2, like 1,200?
1,200, your worship.
Yes,
Yes.
and he's been in the police from 1991.
From
That will be 24 years.
24 years, yes, sir.
I mean 34 years. No, yes.
Yes, yes.
Thank you. And in relation to accused number 3, that will be Mrs. Precious Madondo. When was the previous conviction expunged?
In 2010.
Okay. And how long has she been in the police service?
Oh, 30 years ago.
30 years.
Yeah.
And the net salary?
The net, Your Worship, for accused number 3 is 55,000.
No, I'm sneezing. Sorry, I missed that. What did you say?
The net is 55,000, Your Worship.
55.
55 years.
Sorry that I scared you. It attacks me badly. Yes. And the value of the house?
She's paying bond of 1.9. 1,900.
Thank you.
And for accused number 1, for Your Worship, the net is 51,000.
51.
And he's saying he's paying bond for 38,000.
38,000.
31,000.
So the value of the house is over 3M. Thank you.
Thank you.
And Ms. Ndebele?
As it pleases the corporation, I submit that a proper case for bail was made out in terms of the affidavit, unless
You mentioned, let me guide you, ma'am. You mentioned that he was born in place of birth is KZN.
Yes.
You know how many square kilometers it is? I would have preferred to know the town.
Thank you.
Yes.
Thank you.
Msinga.
Your Worship,
There are no addresses there. It's just a quick King's Place.
Singer.
Yes, I've heard that. The bond. You mentioned something about Colbin. What about Colbin?
I mentioned
The
that
address.
as the place of employment, Your Worship.
Place of employment.
Yes, he is employed.
Yes, no, I have no dispute with that.
Yes.
I have no argument with that. So he works at Mahlambandlovu.
May I have a question, Your Worship?
Yes. Protects the president.
Thank you, Your Worship. It's not Mamothame. It's the address is correct, and the building name is called Tulbagh Park.
Too bad.
TULBAGH, Tulbagh Park.
The value of his house.
Plus minus 1.9 million, Your Worship.
And the net.
The net plus minus 50,000, Your Worship.
Thank you, ma'am.
Thank you, Your Worship.
Mr. Mulefe, proceed.
As it pleases this court, I'm indebted to this court for the indulgence. As the closing remark or closing argument, this matter revolves around an employment of a single person and of a falsified CV as alleged by the state, and also a false statement on employment application form. Therefore, it is my submission that the work is just the amount of salaries that one received from employment in respect of accused number 7 from November to this day. I just wanted the court to take cognizance of that, but really there is no much flesh here. It's just a bone with some threads of meat. It's not a very big deal, like it is made to be, you know. It's just an employment of one person.
Lucky Montana employed a person who was supposed to be an engineer. He was not an engineer, and he got 15 years.
Lucky Montana,
No, that's public knowledge.
yeah, but Lucky Montana did not get 15 years.
No, the person,
The
not
person,
him.
Yes.
You see, it's not just a little bone and with a little flesh.
Unfortunately,
But I'm not saying that will be the case with your client.
no,
I'm
but
just
the-
putting.
I get the sentiments of the court.
Thank you.
And what I'm trying to say is that the period of her employment is from November 2024 until now.
Yeah, at least she did not go and get the oversized coaches.
You are right on track. There is not so much damage here.
We don't know.
Yeah, there is not so much damage, and it should not be exaggerated. Yeah, indeed, my clients are members of the executive. However, they have bonds starting accused number 6. The property is worth about 650,000. It's a townhouse, and and her net is about 48,000. I hope you won't sneeze again. It nearly made people to run away, and I nearly I was forced to tell them that the walk is to see. Now, as we go on, and she's a resident of Pretoria, although she was born at KwaZulu-Natal at Mbange,
Richards Bay.
next to Richards Bay. And he has a car which he's still paying 2 cars, a Honda and a BMW, which is still paying. and that is in respect of accused number 6. Accused number 7 has just been recently been employed to this position. She's born and bred here in Pretoria. The house that she owns is valued at about 900,000. She drives a Kia, this motor Kia 1.6 since 2024, and her net salary is just about 50,000, and she has a bond and all those expenses relating to repayment of cars. What informed the applicants to say 1,000 rand would be appropriate is that really, Your Worship, the amount of damage that or of seriousness of the crime, it doesn't warrant this high amount of bail, because the actual damage is salaries from November up.
But the bail is not so much about the damage is indeed a factor, but bail is about what likely sentence may be imposed if there is a conviction. And that bail must therefore encourage the person to come back. And we have a minimum sentence, if I'm not mistaken.
That is true. And
that is why so you link the minimum sentence that's likely to be imposed to the bail that you set to encourage the person. Is it if put differently, Mr. Mulife, if I'm facing 15 years of imprisonment, I will quickly catch up my pension and go to Swaziland.
You are a pride risk.
That's the message I'm putting across. And therefore bail, that is now in the event that bail is 1,000 rand. Because before I reach Witbank, the petrol would have been depleted, which I would have filled up in Pretoria.
And the other one might say that it's not going to be in his or her own favor to leave the bright lights of Pretoria and to go and live in the rural areas of Manzini there, where there's no water, electricity, and the king is the president.
Freedom is everything. Freedom is precious and everything.
So, it's all about your choice.
Freedom.
Yeah, but you cannot say you are free, whereas you are staying in a mountain as a fugitive. You cannot say that. You might be free to get free oxygen and free sunshine, but you are not free. You are still a prisoner in your own surroundings and in your own heart. In respect of my clients, they are not prepared to leave their children and go and live somewhere else, and also to leave their jobs. They are highly educated. The other one has MBA. The other one has honors degrees, and you just decide to go and live on a mountain with your MBE. And being a magistrate, you live and go and live.
No, that was just the...
I'm just trying to give a context, of how one should view one's freedom. I might be a legal practitioner with little means, but I won't take my freedom and run away from the law and stay in a hole. I won't. Those were times, there were times that we did that, and it was necessary for particular purposes. But right now, everything is nice. We can own houses, we have families to take care of, we've got jobs and so on.
Which is at stake.
Which is at stake, and which is not a train smash. We've got an open economy. You can go to the private sector and do your things. You can open your business and be a shopkeeper and survive. So, and bail is not, it's about securing attendance to the charges. My clients don't feel these charges warrant any of them to run away. Especially accused number 7, whom it is alleged that she has falsified some documents or so, which we will see when the further particulars come. Because before she joins the public sector, she was from the private sector. My apologies, my apologies.
It's all right.
She was from the private sector. He had a very lucrative job, which when you look at what she is earning and what she earned, it's fast different. People come to the public sector to contribute towards the upkeeping of this country, only to find that when they reach into private sector, public sector, there are so many things, and everybody is just looking at you as if you have done something wrong. These are crime intelligence people. If I want to apply for a job there and I give them a certificate, they have all the means to certify themselves that this is correct, this is not correct. Just to come after 4 months or 5 months and say, no, this is not correct, it shows something else. But be that as it may, I want to conclude that it's a public knowledge that inside this division, especially crime intelligence, it's a contested terrain. People who are there, you don't know what they can do. Some people will say their ancestors and come and say the ancestors want this and that. Then say the other one says this and that. So let's let the court not be be so alarmed about this situation. It will come once and it will go on forever and it will be finished. That is my address to this honorable court.
Is she number 7? Is she married?
She is married.
So at least the child is taken care of by the husband. So there's no danger of the child being taken to the children's court if she remains in custody.
Yeah, Your Worship, I wonder if ever you have ever seen a child being raised by a single father, his mother being locked up for a mere certificate. She did not kill anybody. Nobody was ever harmed by whatever that she did. And naturally, a 2-year-old needs her mother. And as a young mother, she needs to raise her own children. The next thing, a child will be coming before this court and having committed heinous crimes. And the social work report says bad upbringing. And when we ask what...
Was the father a bad person?
No.
But
no.
So why would there be a bad upbringing?
No, I'm just saying in an absent mother.
But that's discriminatory.
Well, the world is discriminatory and nature is discriminatory. That is why there is female and male. Well, I don't know both, but that's discrimination, male and female. Black and white. Sunshine and dark. That's discrimination. So let's live along those lines and let others live along those lines. We cannot change what God has created.
No. Let's not get into that territory, Mr. Molefe.
Yeah.
Rather not. I was not getting into that point. I was just raising a case law point that in circumstances like this, the court has to take into account the plight of the child or the children when situations like this are at play.
That is true. And
it was not a matter of gender or those are not. I'm not schooled or skilled or even qualified to make pronouncements on that, except from what I read from the Constitutional Court and High Court.
That is true. And naturally, everybody knows that for each and every person to be on this earth, a woman was a carrier of that person. Therefore, it's natural that she must be the one who takes care of that child. It is. That is my address, Your Worship, unless there is any particular point which the court wants me to address it on, I'll gladly do so.
What's the status of the employment with this situation at hand?
The status of her employment at the moment is that to give the court, she was at her work yesterday, and she was phoned to say, come to Brooklyn Police Station, and we have a warrant of arrest for you. She went there and she was tasked and she was detained. So far, she doesn't know what is happening at work because she was never alerted that there was this impending arrest or not. That will be clear when she's on bail, and I'm sure the subs will give a position on that.
Thank you, Mr. Molefe. Mrs. Flatway, your closing argument.
Your closing argument. address, the state would like to make the following submissions. Your Worship, it is a fact that the case relates to crimes involving dishonesty and abuse of authority that were committed against an order of state. The allegations in this matter also affirm that the accused relate to state capture in that they sought out through their actions and in furtherance of a common purpose to circumvent systems and processes to unduly benefit another. All 7 accused before court are senior members of SABS belonging to crime intelligence. I have already submitted to this honorable court that accused number 1, 2, 3, 4, 6, and 7, they are in the executive management of the entire crime intelligence in South Africa. As accused number 1, Mr. Dumisani Khumalo is holding a rank of Lieutenant General, Divisional Commissioner, Crime Intelligence. Accused number 2 is holding a rank of Major General, Chief Financial Officer, Crime Intelligence. Accused number 3 is holding the rank of Major General, Component Head, Intelligence Analysis and Coordination, Crime Intelligence. Accused number 4 is holding a rank of Major General, Provincial Head, Crime Intelligence, Gauteng Province. Accused number 6 is holding the rank of a Brigadier, Section Head, Personnel Security, Vetting, Crime Intelligence. Accused number 7 is holding a rank of Brigadier, but at the commission of these offenses, she was not employed by the SABS. Your Worship, should the court consider granting bail, we would like the court to take the following factors into consideration. To consider the accused ranks and positions, that there are 4 counts of corruption and 4 counts of fraud against them, the gravity of the offense, as well as the punishment. Your Worship, indeed, this is a very serious offense, and we would request the court, Your Worship, to set strict conditions, bail conditions,
such as
in respect of coming there.
okay,
in respect of accused number 1, 2, 3, 4, 6, and 7. I think I have already mentioned the reason why, Your Worship, because of the positions that they hold. I have mentioned that they are in the executive management of the entire crime intelligence in South Africa. Therefore, we request that these following bail conditions be set. Accused not to contact any employer of crime intelligence.
Employer, employee, you mean?
Employees of crime intelligence at a crime intelligence head office, and that they must consult the investigating officer, senior investigator, B. Padayachi, if need arises.
Contact Padiachi about what? You mean they must contact investigate Mr. Padiachi about what?
If any need arises, maybe they want to contact one of the employees at the crime intelligence.
What is Padiachi's details?
Brian Padayachi. Do you also need the contact details?
No. You put me, you make my imagination go wide. And I'm trying to bring them closer to home about what is the need that would arise that would cause them to make contact with Mr. Padiachi.
That I would not know.
You see, Mr. Padiachi, I need to go to McDonald's. Do you see the problem that I have?
Not really, Your Worship.
Not really. Anything else? Is that all?
No, another condition, Your Worship, would request that their work of firearms to be handed over to the employer.
I thought that was already said to have been handed in when I asked the question earlier.
At this stage, Your Worship, the state is not sure whether the firearms were handed in already. Hence, we are requesting that this be a condition as well, that the firearms be handed over to the employer.
And private firearms?
State.
Yes. Proceed.
Thank you, Worship. Just want to make sure if I haven't left out any other condition. We request that their passports be handed in as well, Your Worship, to the investigating officer, senior investigator, Mr. B. Padayachi.
Is that all?
And just to clarify something, Your Worship, alleged by the defense, in particular accused number 7, the issue of the MBA, Your Worship. The investigation shows that the accused registered this MBA in 2024, and she hasn't completed the qualification as alleged by the defense.
That's part of what you will prove, isn't it, in the trial?
That is correct, Your Worship.
So, okay.
Your Worship, we confirm that investigations in this matter has been finalized. And the state suggests an amount of 20,000 rand towards pay.
What informs the suggestion?
The seriousness of the offense, Your Worship. And the damages involved, Your Worship.
Can you quantify the damage?
At the beginning of this bail application, I have informed the court, Your Worship, that we don't have the exact amount, but it is over R1 million. And and that will be proven when the matter goes on trial.
Mr. Molife says she was employed in November and we are in June. That will be 6 months now, 7 months, maybe. And with the salary that has been given, we have not yet. If you take her gross net to be 50,000 rand, if that is true, that would not have reached that million rand. It will be 1 million rand or so only when we are in November.
The period the period is not from November, it's from the 1st of April 2024 and including to this date, the 27th of June.
All right.
That is the state submission, so
Thank you. And this matter, what do I do therewith?
we have already decided on a date for disclosure, Your Worship. We request that this matter be postponed for disclosure. The date was arranged with the defense, and we have agreed on the date of the 13th of August 2025 for disclosure.
Say the date again, 5 August.
13th of
13 August.
Correct, Your Worship.
Does the date suit you, gentlemen?
Yes, Your Worship, I confirm the date and the arrangement.
I confirm the date.
Confirm, Your Worship.
Where's Brian? Mrs. Hlachwayo, I have one question. In your address, closing remarks, you have argued that the accused should not make any contact with employees of crime intelligence. I have no problem with that, except here is the situation. In one of the affidavits was the accused or the applicants, the spouse is also employed at the same institution. So in effect, I am divorcing them now. Do you see how much of my mind is working?
I understand your concern, Lordship, but when we say they must not contact the employees of CI, we're not saying in that sense, Lordship. If they are married, they will communicate at home or in the street, wherever they meet.
Fact of the matter, so that's why the Englishman says when you put a contract into place, set the conditions clear that no one complains thereafter. I must not put them in an invidious position that that becomes an entrapment.
Understood, Your Worship.
So help me out.
They can communicate with their spouses, but not at the work environment.
Doesn't that defeat the purpose? Hey, wifey, you know I have something in that drawer. Get it so we can use it to, what is the word that they use? To check on the cell phone of that other person.
They can communicate.
So you are putting that aside now?
No, I understand
okay, sorry.
That spouse or she can confirm that she or he is not the witness in this case. Therefore, they can communicate with their spouses.
That spouse is an employee, although not a witness.
That is correct.
And the order is going to say, don't speak to crime intelligence employees. And that spouse is an employee.
With an exception, except for.
Give me that person, please.
The name of the spouse.
Yes.
I noted that no conditions were submitted with respect to case number 5. So the conditions that were the address, they had specifically mentioned 1, 2, 3, 4, 6, and 7, but no conditions were submitted with respect to case number 5, who is the one who has a spouse. So I was waiting to hear what conditions would be recommended with respect to case number 5, because he was excluded.
Yes.
If I can ratify that, Your Worship.
Mm-hmm.
When I quoted accused number 1, 2, 3, 4, 6, and 7, I have mentioned that they were the only accused persons who are in the executive, in the employ of crime intelligence. But the conditions and all the factors that I have mentioned that the court must take into consideration also includes accused number 5.
Earlier I mentioned something about reprobating and approbating. You cannot approve and disapprove at the same time. And it flies on the face of the fact that the reason bail is not opposed is because they are not a threat to the employees. Now it becomes like it's a threat to the employees. That is approbating and reprobating. It's all right. We don't have to. These things do happen. Let's not get our blood boiling. Just switch off your phone. It's all right. It's okay. My blood pressure is low. Which court will they be appearing in on the 13th?
Court 16, Your Worship.
Do you have a stapler, my lady? Thank you. You may stand. The court proceeds to give its judgment on the question of whether bail is granted or not. The state has indicated and given reasons why bail is not being opposed in relation to yourselves, accused number 1 to accused number 7. There are no particular problems or reasons for the court not to accede to those reasons that the state has advanced. With minor changes, the court will therefore accede to those reasons that the state has advanced why you should be granted bail or why they are not opposing your release on bail. You have yourselves also made applications or submitted evidence via affidavits which were accepted as exhibits Exhibit A to H in support of your bail application. It was quite telling, or it is quite telling and observable that from accused number 1, Mr. Khumalo, to the last person, Mrs. Mukweli, it looks like the document that was used to support this application for bail is the same across all of you. Maybe someone gave the document and said, yeah, copy and paste, just change the names, and I will illustrate that. Paragraph, page 1 of each of the affidavits, it's exactly the same, from the heading to the full stop at the last letter or word of the application. Look, it starts with in the magistrate's court in the matter and the state affidavit in support of bail without mentioning any either undersigned. It's only the names that are different. Everything else is exactly the same. It's a one-size-fits-all. That is Exhibit A, Exhibit B, Exhibit C, Exhibit D, Exhibit F, Exhibit G, Exhibit H. Exactly the same. Then you go to the last. Exactly the same, where the commissioning took place. Page 2, exactly the same. Page 3, exactly the same. It's a very disturbing trend that this the standard has degenerated to the point that it has. Accused number 1 has got a net salary of 74,000. Bail amount suggested 1,000 rand. Reason, I will not be able to forfeit such an amount. Accused number 2 has got a net salary as well. Okay, I will skip number 2. Accused number 3 has got a net salary of 55,000. Bail 1,000 rand. Accused number 1 has got service of 34 years, and these now that I am mentioning are factors that were extracted by the questions that the court was asking. If I didn't ask these questions, believe me, I would have had to invoke the provisions of Section 60, subsection 4, 3 and 4, and say not enough information has been put before the court, and therefore the bail does not succeed until these factors have been has been placed before the court. Section 50, subsection 4, 6D rather, Section 50, subsection 6D behooves the court that if there is not enough information that has been put, the court can then say, I'm not in a position to determine the question of bail because lesser information or no information or good information has been submitted. Each time you bring an application, you as an applicant, Justice Haramse from the Supreme Court of Appeal says, at the slightest of detection that that which is contained in the affidavit is not true, is good reason to refuse the application. Justice Haramse from the Supreme Court of Appeal. Now, the matter has not been clarified. I raised it, but it still stands open up to this point of judgment. Accused number 1 lives at number 69 Mayflower Crescent, Centurion, Tshwane. That is according to what the state has got from the docket. But on the affidavit, it is number 68A. No attempt whatsoever has been taken to whether to amend the charge sheet on this point or not. Section 49 of the Section 41 of the Criminal Procedure Act provides when the address, if the accused person, let me put it this way, Section 35 of the Constitution says the accused person has a right to remain silent. But that is then eroded by Section 41 of the Criminal Procedure Act that says every accused person has a duty upon arrest to provide his full names and his address. The defense and the rest of it he can keep quiet about. And when that address is doubted or is incorrect, it is a criminal offense punishable by imprisonment up to 3 months imprisonment. 68A and 69 are two different matters. I'm just illustrating the extent to which the standard has dropped. Apart from this copy and paste that I've already highlighted, across the spectrum, the circumstances of accused number 1, accused number 2, up to number 7 are totally different. Their ages are totally different. Some coming from KZN, some, the circumstances are totally different, but the affidavit are exactly the same. Exactly the same. I wonder why. Ms. Ndebele addressed the court and mentioned in support of her client's application that, for example, says at this stage, where are my notes? At this stage, we choose not to get into, it is not necessary to get into the merits of the case. That is correct. That is correct. But the state has put forward what is the case. Although not in so many, not in evidential material. So we know what the state is going to have to prove in your against you if the case will go to that extent. Justice Krichler in State versus Kitekat, Chabalala, and Dlamini and others says, it is vitally important to know the defense that the accused person has got so that the court is then able to decipher and evaluate the defense against that which the state has got. And in the event that the court finds that there is a cast iron defense, it will be a travesty for the court to keep a person who's going to be found not guilty in custody. The corollary is equally true. The punishment that is likely to be imposed in the event that the accused person are found guilty, that is in the event that the accused are found guilty, given the accession that it is indeed a Schedule 5 offense. It is 15 years imprisonment. Of course, it might be brought down to some other sentence or period of imprisonment, given particular circumstances of a case of a particular person. Now, back to Justice Krichler. In the case that I have made mention of, Skitekat and others, it is not wrong for a person who is facing a sentence of incarceration or custodial sentence that he be kept in custody pending the finalization of the matter. That is from the Constitutional Court. It is not wrong. But so what is it that I compare the state's case against when I have no benefit of any defense except a bad denial? In applications, and this is dealt with it within the ambit of the Magistrates Court Act, the rules, as well as the Criminal Procedure Act. In applications, the applicant has a duty more than the respondent to satisfy the court that the interest of justice permits his or her release. Not to shift the burden to the other side, the respondent. I live here, I work there, but there is nothing that supports, for example, there's no attachment to say, this is where I live. And in support of that, not as an ipsy-dixy, here is my water and light statements attached. I am married, here's my marriage certificate. I have children, here are their birth certificates attached. Things like those. Nothing. Just copy and paste. The only favorable consideration in this application that favors you, all of you, is that correctly said by, partly, not correctly, partly said by Mr. Molefe, that this is there is no particular quantification of the amount. This case is based on a lie. It's not based on fraud as it would be in the conventional sense. That there was maybe a check presented and tried to be cashed in or something like that. The case is essentially that a person who was not worthy of employment got employed by the influence of the others that they hold. That does not mean it is not a serious crime. That does not. It does not mean it does not fit the description of a white-collar crime. And I'm not saying that is a crime has been. A crime has been committed. Whether you are guilty, whether you are the ones who did that or not, I don't know. The state says you did. You didn't. You just say, no, I will plead not guilty. I deny the allegations. Particularly for accused number 7, who would have been the beneficiary of this scheme at all. Does not say what the state says is total nonsense. I have the qualification from UNISA, I have the qualification from Pretoria University, and here is something in that regard to prove that I qualified for that which I have, based on which I have been employed. Nothing. Absolutely nothing. But then the court is informed to come to the decision that it has decided on, not based on what you have put forward before this court, but based on our very beautiful principles of the law. Some criticize the Roman Dutch law. Whether their criticism is correct, I will not comment. But the Roman Dutch law has got very beautiful principles. And I will say something that that influences the court's decision in this regard. We have a principle. It's Latin. Don't stress your mind about it. In favorem vitae libertates et innocentia omnia presumptur. All people are presumed to. The court must presume innocence of people based and also make a presumption in favor of life, liberty, and innocence. That is why I made mention during the deliberations that liberty is quite paramount, although this was taken out of context, but I will not get back into that. Being told about the mountain in a hole and all sorts of things. I will not get better into that. I will just repeat. In favorem vitae libertatis et innocentia omnia presumptur. All presumptions are in favor of life, liberty, and innocence. That is a very beautiful principle of our law, although some criticize our Roman Dutch law. So, in favor of your presumption, not of presumption of liberty, presumption of innocence, but in presumption in favor of liberty, when there has, particularly given that the state is not opposed to you being released on bail. Therefore, the court should emphasize the presumption of liberty. It is based so purely on that. If it was this bail application was opposed, and there was cogent or some iota of indication that liberty should be curtailed, relying on State versus Skitekat and others, that when an accused is facing a custodial punishment in the event of conviction, that liberty can be curtailed. The court would not have acceded to this because there's nothing essentially that has been placed before the court except the copy and paste that the court is settled with. Bail is not about what you have in your purse. Bail is not about what you have in your pocket. Bail is about your means. With the earning capacity that all 7 of you have got, it is quite ridiculous that an amount of 1,000 rand for each of you will be proposed as being the correct amount of bail. Section 60, subsection 2, capital B, dictates that the court should get into an inquiry. Once the court determines that you should be released on bail, the interest of justice justifies that. Then the court must get into an inquiry determining the extent or the amount that which you can afford. Many of you, if not all of you, 1,000 rand is a pocket money. Some of you who've got girlfriends will probably give it to them. You go to Checkers, you buy your Steers or Pizza Hut, you spend that whole amount and that is gone. And you want to tell me you can never afford to lose that amount to forfeit it. Yes, for the person who's homeless sleeping at the street, that is a huge amount. But for a person who nets 74,000 rand, that is nothing, that is peanuts. So much about this copy and paste, this flimsy work that has been done. What favors you is the presumption of liberty. That is part of our law that the court will lean towards in this matter. Nothing stops the court to demand that each of you submit your title deeds to the court as guarantee for your release on bail. Nothing. Then we know that the likelihood of evading trial or eloping against this charge is quite minimized when we have your title deed. Because that 3.5 million rand house, that 4 or 5 million rand house will then be forfeited to the state. And the court has the authority and power to do that. Section 60, subsection 2, and other instruments of the law allows the court to do that. I'm just saying these things, particularly talking to your lawyers, as I have made mention in the way that, the sloppy way that these affidavits were commissioned. Some of them were commissioned in my presence. I'm just looking, saying, oh, cry the beloved country, to quote Alan Patton. I've mentioned the case that says when an affidavit, a statement supposed to be an affidavit is as in the way that this has been, the court has a right to reject it and say there's no affidavit, therefore there's no evidence. And in the absence of evidence, which Section 60 demands, then there would not be any bail for you. But be that as it may, in favor of your liberty, with the likelihood that the state has also not presented a very, very convincing case in this regard. I don't say there is no case, but the case is not convincing. The court will accede to your release on bail, as I have already alluded to that aspect. And that being the case, for accused number 1, Samuel Dumisani Khumalo, for accused number 2, I beg your pardon, for accused number 3, Nozipho Precious Madondo, accused number 4, I beg your pardon if I pronounce your name otherwise, I mean no offense. Maperimisa Josias Likalakala, for accused number 5, Sydney Zwelithini Gabela, for accused number 6, Pindile Cynthia Ngube, and for accused number 7, Dinewo Mukwili. Bail is, you are therefore granted bail, or your application for bail succeeds on the following conditions. Firstly, the amount that is set for each of you is 10,000 rand. There's no reason to really discriminate on the amount. All of you, this amount is well within reach. If not immediately, it can be reached at some immediate time before the setting of the day today, I believe. And furthermore, there are conditions that the court is going to set for you, and the conditions are as follows. For accused number 1, 3, 4, 5, 6, and 7, all of you are prohibited from being at any premises of crime intelligence within the country or Republic of South Africa while the matter is pending. In the event that there are any items that you need to retrieve from your desk or such, then you will make contact with Brian Padiache, who will assist you with the collection of any matters or items of personal nature or that you may have left at your premises of employment at crime intelligence. The matter is postponed until the 13th of August 2025 for Section 32 of the Constitution to be put into effect. The so-called disclosure. There's no disclosure in Section 32. It is, you're entitled to the contents of the police docket, the relevant part, not all parts of the police docket, to be, so that those documents or material is placed in your hands. Accused number 1, 3, 4, 5, 6, and 7, you are currently in custody. You remain in custody until bail is paid. When bail is paid, you must ensure that on the 13th of August 2025, you are at court number 16 at 8:30 in the morning. Do you understand? Very well. And as for accused number 2, in his affidavit, he disclosed that he has a pending case of corruption. And this current case also being corruption under Schedule 5, it therefore reverts to Schedule 6. So it was a misdirection to say that this is a Schedule 5 offense when it is actually a Schedule 6 offense. And the dictates of Section 60 in relation to being a Schedule 6 offense, exceptional circumstances being proven, has not been placed before the court. Therefore, it will be a misdirection by this court as well if the court were to entertain this application as a Schedule 5 when it is actually a Schedule 6. Because 5 plus 5, as I've said, is Schedule 6, not 5 again. Therefore, for accused number 1, there is in essence no bail application because it was a misdirection at all. I cannot convert it into anything else. When it is ultra vires, the court cannot take cognizance thereof until a proper bail application under Schedule 6 is brought to the court. Therefore, accused number 2 remains in custody and until the 13th of July of August 2025, unless the matter is expedited for the consideration of bail under Schedule 6. I cannot go back to to Section 60, subsection, I beg your pardon, Section 50 of the Criminal Procedure Act and say within the 7 days, because there has indeed been an attempt, albeit a misdirected attempt. And when you make a bet and you fall by it, very well, you are then excused. You are excused. I'm still going to do some admin work here with my lady.